Hello and good afternoon. I would like to welcome everyone to today's webinar, Immigration Compliance in a Remote Work Setting. We're happy to have you here. Before we begin, we'd just like to go through a few brief housekeeping items. So today's session will be about 45 minutes long, and that includes an audience Q&A at the end of the presentation. And just a note, this webinar is being recorded and we will send you a link to download the recording after today's live session. We also encourage you to ask questions throughout the presentation. To do so, please use the question function you see on the right-hand side of your screen. And last thing, just so you're aware, today's webinar is being conducted remotely, and while we don't anticipate any disturbances, please excuse any audio-visual issues that you may experience during the broadcast. Awesome. So just for some of you who are not aware of us, for nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. We combine a top-ranked legal team with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. We secure work authorization in over 150 countries. We've grown 37% year over year, and we work with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. Before we begin, I'd just like to take a moment to welcome today's presenter, Christopher Preston of Global Immigration Associates. Christopher is a managing attorney at GIA. His practice focuses on helping businesses and their employees maneuver the U.S. legal immigration and work authorization landscape, and that includes employment-based non-immigrant visa and employment-based immigration matters, I-140 petitions, and adjustment of status applications. Christopher works with clients in several industries, including data analytics and engineering. Prior to joining GIA, Christopher worked as an associate attorney at Ogletree Deakins, where he provided full slate business immigration services to major clients in several high-tech industries, including engineering, consulting, mining, and finance. Christopher, it's great to have you here.
Thank you, Nidhi. It's great to be here.
Wonderful. So just to run through today's agenda, we're going to start by discussing what remote work today looks like and the challenges that it can create for organizations. We'll then jump into a discussion of some common immigration compliance related issues that organizations might run into while working remotely, followed by some helpful practice pointers that can help your team stay in immigration compliance. We'll finish up by taking some questions from the audience before we conclude this session. And like I said, you can ask questions by using the panel on the right-hand side of your screen. And just a quick note before we begin that the content in this presentation is not intended as legal advice, nor should it be relied on as such. For any additional information on the issues discussed, please consult with your immigration counsel. So let's start by taking a look at remote work today. Many employees are now working from home, and because of this, immigration and global mobility initiatives have been temporarily halted. While some of the changes and restrictions implemented by USCIS and the State Department have been lifted, most employees are still working remotely, and organizations have had to adapt their processes and policies accordingly. To better understand how global mobility and immigration professionals are adapting to managing a remote immigration program, Envoy Global conducted a survey back in July to get a sense of what was happening. What we found was that nearly all respondents have implemented a work from home policy due to the pandemic, and a large majority said that they've been working from home longer than 6 weeks. Luckily, the transition to remote work has been easier than expected for some. In fact, approximately 41% said the transition was very easy. However, others did report some minor difficulties with transitioning into a remote work environment. For immigration and mobility professionals, part of the transition has required shifting immigration processes online. Chris, could you just speak a little about the importance of immigration compliance during this time?
Absolutely. Thanks, Nidhi, and thanks for everyone being on the call today. So I think it goes without saying that this has been one heck of a year. It's been one of well, I think we can safely say it's been the most chaotic, unpredictable, and confusing years in terms of U.S. Legal immigration. And because of that, legal compliance has really become something that employers need to pay more attention to than ever. Legal compliance in the U.S. immigration context has always been important, but particularly now when the world is changing rapidly, and COVID related issues change the employment landscape. They change the travel landscape for foreign nationals, and all of these legal issues that we take into consideration. It's really important to put a microscope up to exactly what the government expects employers to do and not to do. Among the federal agencies that we touch base with on a day-to-day basis in U.S. legal immigration, among which are Department of Homeland Security obviously is the biggest one. That contains USCIS, U.S. Citizenship and Immigration Services. It contains U.S. Customs and Border Protection, CBP, and Immigration and Customs Enforcement, ICE, as well as the Department of State, who administer the U.S. embassies and consulates around the world and are responsible for issuing visas for international travelers. And then finally, the U.S. Department of Labor, who is responsible for administering programs, particularly for the H-1B visa and the PERM labor certification process. Among these agencies, some have carved out flexibilities with regard to legal compliance due to COVID. The Department of Labor has been particularly, relatively accommodating compared to the others. Agencies like the Department of State have created exceptions to wide-spanning travel restrictions. And USCIS, not surprisingly, has pretty much been in the Department of Homeland Security as a whole, has not surprisingly been one of the staunchest and most stubborn agencies in terms of changing the things that employers need to do and what they need to stay away from. And there are a lot of instances where counterintuitively, the government has not bent or created flexibilities with regard to compliance issues, despite the fact that employment in the United States right now looks completely different than it did a year ago. And so it's incredibly important to stay on top of those developments, what has changed, what has not changed, particularly what has not changed, because I think a lot of employers expect the government to be understanding. People working from home, what does that mean about H-1Bs and labor condition applications? What does it mean for PERM? Some of these things have not changed, despite the fact that the circumstances call for it to change. And so we have to constantly be aware of what the legal compliance landscape looks like, particularly in the times that we live in right now. In addition, sorry, Nidhi, one more point, and I promise I won't get political, but right now, immigration, I think we can all be honest, it is a political football at the moment. The current administration right now prioritizes enforcement, particularly among past administrations they have for the past 3 years. And I think right now, at a time when immigration enforcement is can be used as a politically advantageous tactic, employers need to be wary during these moments when the federal government wants to make enforcement a priority. And so anytime that we're in a political season like this, no matter what the partisan landscape looks like, our business ends up, can end up on the front page of, when I say our business, I mean the work we do. U.S. immigration can end up on the front page of the New York Times, which is not where we want it to be. It's usually bad news. And we've seen that happen in the past few months. We've seen a lot of headline news items about immigration crackdowns, travel restrictions, et cetera, et cetera. So, the political landscape as well makes this particularly sensitive area. And so that's just another reason why immigration compliance is an area that we want to tread lightly, particularly right now.
Awesome. Thanks so much, Chris. Great explanation right there. Yeah, so on that note, why don't we take a look at some common immigration compliance issues that might arise when organizations are working remotely as they are right now. Chris, want to dive in?
Absolutely. So, remote work has pretty much been the leading topic and the leading source of questions that we get from our clients and that we have been getting for the past 6 to 7 months. We're going into a mandatory work from home next week. What does that mean for our foreign national population? What does that mean for our H-1B visa holders in particular? Because that is, as I'm sure most of you are aware, the most prevalent non-immigrant work visa status that most employers rely on to hire foreign talent. What do we have to do with LCAs? What do we have to do with posting notices, et cetera? It's been a huge source of confusion and a topic that we have been looking at quite closely. One thing to understand is that only a certain only a certain amount of visa types does work from home really become relevant in terms of staying in compliance. Those two particular visas are the H and the E3. H1B, plus if you have H1B ones from Singapore or Chile, fairly rare, but they would fall into the same, topic of discussion here. These are work visas that are wage controlled, by which I mean, in order to hire somebody who is in this non-immigrant visa status, when I say non-immigrant, I mean a temporary guest worker, right? Someone who is entering the United States temporarily to work in a U.S. role. Any folks who are in these visa categories are they must be paid a salary that is commensurate with similarly employed U.S. workers in the same occupation and geographical area. Now, I want to underline geographical area, right? So when we say that these are wage-controlled visas, it depends on where you live. So somebody who works in, Midtown Manhattan is going to have a higher prevailing wage being the term that we use as the wage you have to pay that employee to remain in compliant status in H-1B or E3. That employee is going to make a higher prevailing wage than somebody in, Lincoln, Nebraska is going to make, just due to little regional microeconomies. And so, because that's relevant in the compliance context, the work site that is reported to USCIS on that employee's H-1B or E3 petition, the last time that you sent a petition to USCIS requesting sponsorship of that employee in that particular status, the work site, if that changes, that becomes legally meaningful. If you have an employee who, you filed an I-129 petition to employ them in H-1B status in January, and you're headquartered in Chicago, Illinois, March comes around, you're implementing a mandatory work from home. You have, Jane Doe as an employee in H-1B status, and Jane comes to you and says, I want to work from home in Sarasota. What does that mean? Well, that means you should get in touch with us, or you should get in touch with your legal advisor in this area, because that is going to mean you're going to have to take some kind of legal action to keep Jane in compliant H-1B status. Now, the big distinction that we make when it comes to where the person is working, and for example, if they're going to be working from home, where is their home, literally, or where is the you know uh, physical location that they'll be working in? We compare that to the worksite address listed in their most recent petition, and we determine if it's outside the what we call the MSA, or the Metropolitan Statistical Area, which is really just a fancy word that means um, the metro area in which they're working, and or um, a place that is within the reasonable commuting distance of the address listed. So if Jane was working in downtown Chicago, and now she's going to be working from home in say Oak Park or something like that, a suburb, that's going to be considered the same MSA. It's generally within the same sort of metro area, and people commute from that area, or can commute, and so that's going to be considered within the MSA. Now, a move within the MSA, that's good news, because it doesn't mean we have to take nearly as much action as we otherwise would have. But it doesn't mean we don't have to do anything. It does mean that we have to effectively take the labor condition application, the LCA, which I'm hoping most people are familiar with. If you're not, a labor condition application is a certification that we get from the U.S. Department of Labor that the employee will be making the prevailing wage under the petition. We have to take that labor condition application, a copy of it, or a posting notice, basically memorializing what's in that LCA, and we have to repost it in the new worksite location. So in this case, Jane's home. Now, I have to give this sort of disclaimer. A lot of times when I'm having conversations about immigration, this is not going to make logical sense to you, and I perfectly realize that. But sometimes we'll have to take a piece of paper and ask Jane to post it in her house, which is a little bit insane, but it is in accordance with the black letter law and regulations in this area, because the posting notice has to be put up in the work site. In this case, someone's working from home, that work site is their household. The Department of Labor has when there are conversations between our immigration bar, our American Immigration Lawyers Association, and the Department of Labor, conversations have arisen where we've said to the DOL, "Are you serious? Do we really need to have our employee post a piece of paper on their refrigerator where no other employee is going to see it?" Sometimes they've said no in a kind of informal way. They said, "We realize that's ridiculous, and it's not really notifying anybody else." And then another memoranda, they've said yes, because that's what the regulations say, and we really don't have any capability to say that you don't have to pay attention to those regulations. You still do. And so I do recommend to my clients who want to be 100% compliant that we have to send Jane a PDF of the LCA and instruct her to print it out and post it in her house for a small period of time. It's ridiculous, but obviously it's not very onerous. It's not very difficult to do. It's just a little bit more legwork to make sure that there isn't any doubt whatsoever about her compliance working from home in that context. If it's within the metro area, if it's she's just moving across, she's just going to work from home across town or in a suburb, it's typically going to be we're not going to need to file anything with the USCIS. It's basically going to be an internal compliance step, and at any time Department of Homeland Security wants to audit your records, you'll have a record within your files, your public access file, that says this was done and everything that needed to happen happened. If it's outside the metro area, again, if Jane wants to work from her parents' house in Florida, outside, clearly outside the metro area across the country, that is going to require a filing with USCIS. And the reason is because the regulations require us to file an H-1B amendment petition anytime there is a, quote, material change, unquote, to the employment. A few years back, in a court decision, it was held that a move outside the metro area is a material change. So somebody who moves across the country, the government doesn't consider that insignificant. They consider that they consider that significant because again, the prevailing wage rates change when a dramatic move like that occurs. And so we will have to file an I-129 petition with USCIS that updates the address and basically go through the same adjudicatory process. So the USCIS will say, is this a specialty occupation? Does the individual have the proper education qualifications? Does the company have the ability to pay the prevailing wage? So they go through all that again, even though really we're just saying, look, she's just moving across the country. So it is a little bit more of a significant step, but one that is required nonetheless. So those are the biggest items when it comes to work from home or changes to job location. When we're talking about perms, typically it's not that big of a deal because when we file a perm and an I-140 and we're getting ready to for the foreign national to apply for the green card, we're looking forward in time potentially to, even if you have employees from India, potentially 10 to 15 years away. And if you expect that person to eventually relocate back to the office that was listed on their perm, then it's totally fine. We don't need to change it in real time. So typically it's really H-1B and E-3 that we have to take a look at in the moment and say we have to take immediate corrective action for us to stay in compliance.
Thanks, Chris. Want me to go ahead and move ahead?
Yeah. Yeah, so with the I-9, this doesn't relate as much to work from home. The reality is that with I-9, basically I-9 again is a process by which, your employee, whether they're, no matter where they're from, all of us who are US citizens have filled out I-9s, and it's kind of silly because it's like, well, we're US citizens, what's the deal here? But it does apply to every employee, and it's not really relevant, whether they're working from home or not. They still have to document their identity and their work authorization in the United States. But what is good to be updated here is that DHS has been flexible on this particular area when it comes to the documentation that an employer can accept to onboard an employee and get them working, specifically because effectively COVID has, rendered USCIS incapable of doing their jobs in terms of printing and delivering employment authorization documents, also known as EAD cards. DHS carved out an exception that allows employers to complete an I-9 if the foreign national has an approval notice for their EAD application. So that's a little bit jargony, so let me break this down. So typically what happens is the employee applies for an EAD, and by the way, this is a totally separate form of work authorization, aside from H-1B. Typically you're looking at spouses of H-1B, so if you have employees in H-4 status who are eligible for an employment authorization document, that's how they can get working in the United States. That's a huge population of EAD recipients. Same goes for dependents of L1 visa holders, so L2s. H4s and L2s are both eligible for EADs in certain circumstances. So typically what happens is that individual has to send an application to USCIS for the EAD, right? And the government reviews that, approves it, and then sends them a document immediately. It's known as a Form I-797. That's basically the approval notice. It's just a piece of paper that says, congratulations, we approved your EAD application. It's valid for, date A to date B. What has happened this year is that the card, the actual EAD card, which looks a little bit like a driver's license, there have been serious breakdowns in USCIS's ability to print and deliver those cards. And traditionally, the I-9 has required the actual card. It doesn't matter, it didn't matter if the employee shows up with the approval notice. Strictly speaking, the employer said, I can't accept this. The form says that this is not, an acceptable document. It says that an EAD card is acceptable, but it doesn't say an approval of the EAD card. Well, that has changed now. Now DHS says if the person has the approval notice, we'll let you complete an I-9. They don't have to wait for the EAD. We're acknowledging the fact that we're taking forever and getting these cut and delivered. And so that is a particularly piece of good news because this was causing monster headaches for a lot of employers in this sector. I'm sure that some of you have felt that pain as well. And so, as part of this sort of rearranging COVID landscape, this has been one silver lining and one area of flexibility from the government.
Awesome. Thanks, Chris.
And finally, this is another huge topic, furloughs and reductions in force, layoff. A lot of employers have gone through these, and with obvious reasons. This is something that if you have foreign nationals who are in an H-1B status, in a wage-controlled status, and they get a reduction in pay, something to definitely let your legal advisor know. It could affect whether their employment is still in compliance because, again, an H-1B is a wage-controlled visa. And if they dip below the prevailing wage, technically they're not maintaining status. So that's something that we definitely want to know. Also, if you have foreign nationals who are in H-1B status or really any kind of non-immigrant status like L2 or if they're on F1 OPT, if in other words, if they're a student and they have an EAD card, which we just discussed, and they're laid off, or they're sent home. It's not just a reduction in pay; it's an actual you're in inactive status. You're not working for us for the next 6 weeks or something like that. That could be critical to their status. For an H-1B, they would no longer be maintaining status if they're inactive, if they've effectively been quote benched, as the U.S. government would term it. So it's definitely something you want to let us know. Because it could have negative ramifications for their status, and it could mean that they're out of status. And then finally, in terms of the perm, and this is really particular, something you want to keep a lookout for if you're filing perm labor certifications for your employees. Even if your employee was not affected by layoffs, even they kept their job, their pay remained the same, their employment, basically like nothing happened. If the employer lays off other workers in the same job, that has impacts on this particular employee's perm process. And the reason is this: the perm requires us to show that the company could not find any qualified, available, and interested U.S. workers for the job opportunity that's being sponsored for. And so as part of that process, the employer goes through a series of job posting methods to basically test the labor market. And if there were layoffs in the same position in the previous 6 months, the government wants the employer to consider the laid off workers in addition to anyone outside the company who's applying for that job in response to those job posting methods. And so in addition to the normal job postings, you also have to send a notification to all employees who were laid off from that particular position in the same worksite location. And if they say, you laid me off 3 weeks ago, I'm still interested in this job, and they send you their resume, you have to consider their resume as part of that perm process. And if they're qualified and they're saying, I'll show up tomorrow and I'll take this job back, then effectively you can't proceed with the perm. You don't necessarily have to hire that person back, but we can't file the perm if we have a U.S. worker out there who says, I'm qualified, I'm available, I'm interested in this job. That perm is not going to be approved because we haven't met our burden of showing that the company could not find those kinds of U.S. workers. And so typically what that means is either putting the perm process on hold until we're out of the 6-month radius of those layoffs, or just going ahead and notifying those ex-workers, seeing what they say. And it's like maybe they said, they say, I don't care about you anymore. I don't want to come back. And in which case we may be able to proceed. But suffice it to say, for the here and now, if you have layoffs and it may impact the perm process that you're trying to file right now.
Awesome. Thanks, Chris. And I think we did have just one more point to touch on, which was maintaining and storing records.
Yeah, this is one area where USCIS has shown some flexibility with regard to the COVID situation. Basically, in fairly early on, they said, look, we're not going to be sticklers about original signatures on government filings, which they were before. They would have somebody in the mailroom holding your piece of paper up to, fluorescent light and determining whether it was an original signature and potentially sending it back to you and saying no good if it was a electronically reproduced signature. Now that's all changed. Effectively, USCIS does not need an original signature, but they do need the signature to be electronically reproduced, by which I mean DocuSign is no good. If it's something, that it's an electronic stamp that says, Christopher Preston has signed this, it's not the same thing. They want somebody to put pen to paper on their desk, but it's okay if they've scanned it, and it's now in a, electronically reproduced form. So it's a little bit of a fuzzy distinction there, but effectively what I tell clients is that it needs to look like an original signature for it to work. A DocuSign is going to be rejected. It's probably not going to be accepted as legitimate. And just one thing we throw in here, storing paperwork and records in a secure digital location can make immigration process quicker. Envoy has capabilities in terms of public access files, which we'll talk about in a little bit, which can be maintained in our system, but always a good idea to keep things safe and flowing more quickly.
Awesome. Thanks, Chris. Thank you for touching on these common issues. And with that being said, let's move on and take a look at some practice pointers that might be helpful for helping immigration and mobility professionals stay in compliance and, keeping their organizations from being exposed to risk. Chris, could you speak to that?
Certainly. So these pretty much go for, whatever year we're living in, COVID or no. Hopefully next year we can say no to that. But run regular audits to your employees' titles, locations, and salary. As you've heard me harp on during this call, this is all relevant information for your H-1B employees, because if there's a quote unquote material change to their employment, an amendment filing may be necessary. So if their job changes dramatically, it's something that you want a lawyer to look at and say, yeah, I think an amendment is necessary here, or no, it's not that such a significant change that anything is necessary. If their salary drops, potentially bad news in terms of the H-1B. If it goes up, usually it's a non-starter. That's fine. There's room built into the legal structure to allow for that to happen. Changes in job location, again, like we discussed, can be very important. And no matter where they're moving, we have to do something, unless they're moving within the same office, the same office building. Create automated reminders and alerts for expiration dates. We do that if you've retained us as your legal counsel. If not, if you have a GC who's handling immigration or your internal legal team, always a good idea to create reminders for I-797 expiration dates, I-94 expiration dates, passport expiration dates, visa stamp expiration dates. These all can have different ramifications. The most important for if you're not tracking anything, what I would say is track everybody's I-94. Tell your employees to constantly monitor their own I-94, because they can travel in and out of the country without you knowing it. They can take a trip on a lark. Well, maybe not in these days, but in traditional times, they can take a little vacation to anywhere, South America, France, whatever it might be, they get a new I-94, and we won't know what it says until somebody looks. And typically, you're going to have to put the onus on the employee to do that, or they can just let you know when they travel, and either you can do it or you can have us or your legal advisor do it. But some system in which they're letting you know that they've traveled internationally, because CBP can and will make mistakes on an I-94, and sometimes not fess up to the fact that they are mistakes, and all of a sudden we have a status problem for that particular individual. So in any event, if you're not tracking anything, I-94 is the most important, because the I-94 is a document that controls how long that foreign national can stay inside the United States. When it comes to other things like visa stamp, passport, those are typically just related to travel. So if a person is kind of a homebody and never really leaves the U.S., not going to be as critical. But you always want to monitor that I-94 and make sure that person's maintaining status. And then staying up to date on policies and immigration updates. Envoy has, emailers and blog posts and stuff that you can stay in tune with, and we keep that, pumping out new information pretty much on a daily basis. So definitely check that out.
Awesome. Thanks, Chris. And obviously, we could also go into specifically, you mentioned public access files, any practice pointers in that area?
Yeah, public access files, again, are related to labor condition applications. So if you have H-1B or E-3 employees, you have to have a public access file. Effectively, what it is a file. I mean, it's right there in the name, public access. What that means is that you are keeping a file of records that anybody within your company or within the United States government has the right to look at. And that's effectively compliance documents related to labor condition applications and the posting notices that are necessary anytime you file an LCA. And so, if an employee says, I want to see, your LCAs, you have a legal obligation to make that accessible to them. As you can imagine, does not happen very often. But what does happen more often is the Department of Homeland Security, does a site visit, says we want to go through your public access file, we want to look at your LCAs, make sure you posted notices in the proper way. So it's incredibly important for employers to stay on top of this, make sure that it has the documents that it needs to have. And so the pointers that we provide here are automate as much as possible. So, if you have, posting notices for LCAs have to go up for a certain amount of time. So automating, reminders for when those have to go up and when they have to come down. It's a great practice. Store your public access files document in a secure online location. You'll note that the file doesn't have to be physical. It can be a digital file. And so, doing that online can make it much more easy to work with and seamless, and also searchable if you need to do that. Leverage alerts and reminders, that kind of goes into automation. Envoy has those kind of functionalities as well. And just stay informed of, your public access file. Audits are good. Our clients retain us to run audits of their public access file to tell them what they're missing and what needs to be added. So all great pointers to always make sure that your documentation is in order in the event that it ever gets audited by the U.S. government.
Great. Thanks, Chris. That brings us to the Q&A session. Before that, Chris, did you have any final remarks you'd like to make or anything else to add?
I don't, other than this is really just a dip of the toe in the water of sort of COVID related immigration topics. So please, go to Envoy, go through our blog postings. We've posted a lot of information about, different COVID related updates. So certainly this is not everything that has happened in the last 6 months, but yeah, educate yourselves and always let us know if you have any questions we can answer for you.
Great, thanks so much. So yes, that brings us to the audience Q&A portion. As a reminder, to ask questions, you can use the question function that you see on the right-hand side of your screen. Also, as another reminder, we cannot answer any specific questions about cases. So for any case-specific questions, please consult your immigration counsel. And I do see that we've gotten a few in. Please don't mind any pauses. We just need to make sure that we can answer these questions. But Chris, I think I see a few that are coming in already that you should be able to speak to. So here's one. So using approval notices in absence of EAD cards for I-9 verification, how long will that remain valid? Will we be able to do this as long as the national emergency is active?
Yeah, so the USCIS, they put a specific date in which the approval notice was issued, and that was let's see, let me just find the so the I-797 approval notice needed to be issued between December 1 and up to August 20 of 2020. And so that has been the exception that USCIS has carved out, or DHS has carved out for I-9. And so, you know, you want to make sure that the approval notice was issued in that window. It's possible they update this, but I can't really speak to that. I hope they do. I hope they realize, because right now EADs are not coming any faster than they have. And so the immigration bar will continue mounting pressure on DHS to make this, you know, a more you know, a longer exception in terms of the time in which it's acceptable for employers.
Great. We also had another one come through about EADs. So with the L2 H4 approval notice being used in place of EAD for now, does this work for those on F1 OPT/OPT STEM renewals or marriage-based approval notice, but an EAD hasn't arrived?
Yeah, so effectively the flexibility is not limited to any particular type of EAD. It's just if the person shows up with an I-9 and says, I'm work authorized on the basis of my employment authorization document approval notice, it doesn't matter whether they're H4, L2, AOS pending, F1 OPT. One thing to note, if you didn't already, is that if somebody files a STEM extension to their OPT, they're actually immediately work authorized on the basis of having filed that EAD renewal application. You may have already known that. That's you know, there are a couple examples of EADs in which just filing the renewal actually grants the person immediate automatic work authorization, but for H4s and L2s, that's not the case. So, but yeah, it doesn't really matter what kind of EAD they're showing up with. Right now, USCIS is taking forever on all kinds of EADs. It's not a particular type, so it's not limited to any particular eligibility criteria.
Great. Thanks, Chris. Just to be mindful of time, I think we're going to do one more question and then we will have to wrap up. But here's another one that you should be able to answer. How many days do those on H-1B, L1, L2, E2, E3, and F1 OPT have to find work at a new employer before they need to return home? Is it 60 days, and is this for all visa types?
It's a great question. It's so for the ones that you mentioned, so H1B, L1, E2, E1, E3, those are all going to have 60 days. That was a rule, a 60-day grace period that was promulgated back, I want to say 2015, 16 by the Obama administration. Other visa types are different, but the major non-immigrant visas that I just mentioned will be subject to a 60-day grace period, in which they have to either find other sponsor employer or depart the United States. So if you file an H-1B change of employer on day 59 after being terminated, then technically you're okay. It's okay that you've been unemployed for the last 59 days if you're still within that 60-day grace period.
Awesome, great, thanks. And I do think we can probably manage one more question that just came in. So with so many companies working remotely these days, what would the best practice be to actually post LCA notices?
Great question. Best way is to post, there are actually two ways you can post an LCA posting notice. You can post it physically in the physical workspace, or if the company has an electronic intranet, in other words, a web page or series of web pages that your workforce has access to, everybody in the company has access to, to review, any kind of posting notices like OSHA notices, those kinds of things. If you have a web page that folks go to see those kinds of things, you can post the LCA posting notice there as opposed to tacking the piece of paper up in an empty office. So that's the best way to do it with work from home is do it through electronic posting, which is perfectly legal. If you need more, details on exactly what that notice needs to say or what it looks like, you can always reach out to us. We'll be happy to give you an example.
Great. Thank you so much, Chris. So that brings us to the end of our webinar. But before you go, I would like to draw your attention to a couple of our upcoming webinars this month. Next week, we'll be holding a session on the role of hiring managers in the immigration process. And on September 22nd, we will be holding another webinar about the e-treaty visas. So be sure to join us for those if you're interested. Also, if you're not already, be sure to follow Envoy Global on LinkedIn, Twitter, and Facebook for additional news, policy updates, and trends. As a reminder, attendees will receive a recording of the webinar along with the slide deck and SHRM and HCRI educational credits in an email tomorrow. We'd like to thank all of you for attending today's webinar, and Chris, thank you for being here today.
Thank you, Nidhi, and thank you, everybody.
We hope you have a lovely afternoon. Have a nice day.